Hi, my name is Kathryn Shores. I'm a trust and estates attorney in Lake Forest, and today I'm going to be talking about required periodic filings in guardianship estates. Your first consideration when determining your filing requirements in a guardianship estate is to consider which type of guardian you're dealing with. Guardians of the estate have different filing requirements than guardians of the person. Next, you should always look to the Probate Act to determine when and what you need to file. However, the Probate Act is somewhat general in its filing requirements, so you should also look to the local rules of your court in which your guardianship is pending to determine what your filing requirements are. Often, they will be more specific in the local rules than in the Probate Act. Now let's discuss 3 required filings in guardianship estates: the inventory, the accounting, and the annual report. First, the inventory. The inventory is governed by Section 14-1 of the probate estate. The inventory must be filed within 60 days of issuance of letters of office and is required to be filed by the guardian of the estate. The guardian of the person has no duty to file an inventory. The inventory must be verified and must include all real and personal assets of the ward of which the guardian has knowledge. Note that this includes not only assets within the guardian's control, but also assets outside of the guardian's control of which the guardian has knowledge. The inventory should include all real and personal assets of which the guardian is aware. This should include not only assets within the guardian's control, but also assets of which the guardian is aware but does not have control. The inventory should also include all liabilities of the ward, including mortgages and encumbrances, as well as leases on real property. The inventory should also include any causes of action of the ward. This would include not only pending causes of action filed with a court, but also potential causes of action of which the guardian has knowledge. The format of your inventory will largely depend on the local rules of your court, but at a minimum should include a numbered list of assets and a brief description of each asset. Next, let's discuss the accounting. The accounting is also a requirement of the guardian of the estate. The accounting is the method by which the guardian informs the court and other interested parties of the guardian's use of the ward's assets during a period. The accounting is governed by Section 24-11 of the Probate Act. The first accounting is due within 30 days of the expiration of 1 year from the issuance of letters of office. Further accountings are due as requested by the court, or at the latest within 3 years from the last accounting. There is no particular required format for the accounting. However, the accounting should inform the court and all interested persons of the guardian's use of the ward's assets during the period. At a minimum, the accounting should include the assets on hand at the beginning of the period, all receipts, all disbursements and distributions, and the assets on hand at the end of the period. Many courts and judges will have sample accountings demonstrating the format they desire for their accountings. This should be followed where practicable. However, the format of your accounting may vary depending on the assets of your estate. In addition, the accounting must be verified. The burden, if challenged, is on the guardian to prove that his expenditures from the estate were legitimate. Accordingly, the guardian should keep good records and receipts of all transactions to support his accounting. Once filed, the accounting should be noticed up for hearing and approval by the court. Note that while the court may approve the accounting, the ward always maintains the ability to object to the accounting after regaining competency. Further, the court may never approve malfeasance by the guardian. Now let's discuss the annual report. The annual report is required to be filed by the guardian of the person in a disabled adult's estate. There is no duty to file an annual report by the guardian of the person in a minor's estate. However, the guardian of the person in a minor's estate does have a duty to inform the court if the minor's address changes within 30 days of the change of address. The annual report is governed by Section 11A-17B of the Probate Act. The report must include a statement of the ward's current mental, physical, and social condition, the ward's current living arrangements, the services provided to the ward during the period, the visits and activities taken on behalf of the ward by the guardian, a recommendation as to continued guardianship, and any other information requested by the court. Most courts will provide a form for the guardian's completion of the annual report. Once filed, the court has the authority to take such action as it deems necessary pursuant to the report. These are the 3 required periodic filings in a guardianship estate. Failure to file may result in a citation or even removal of the guardian. So it is important to keep track of the guardian's duties and deadlines in the guardianship estate. Thank you for watching. For more information, you can visit the ISBA's online CLE archive.